Want to know how you can gain access to capital to jumpstart your journey to entrepreneurial success? For entrepreneurs who are just starting out or those who have been in business for years, Minority Business Access is your podcast. Welcome to our show, where we will guide you in avoiding the pitfalls and thriving in your chosen business. Now, on to the show with your host, Solomon Ali.
Kevin, it is so exciting to be here with you on Minority Business Access, and I'm so glad to have you as a guest on Minority Business Access. Can you just tell the audience a little bit about you, Kevin?
First, Solomon, I've known you for a while. Thank you for having me on. I really appreciate it.
The privilege is all mine.
Well, there's many facets of me, but on the business side, I'm a lawyer, and my particular expertise is in the lawsuit protection and privacy planning. We have lots of actors and ball players that want privacy is usually the drive, and lawsuit protection is good for them too. We have business owners that come to us and say, you know, I need lawsuit protection, and then lowering profile and other things are concerns of their family. So I do offshore trusts, domestic trusts, privacy companies. My firm, about 28 people. We've got litigation team. We've got 3 tax attorneys. We do charitable trusts, foundations, all the normal wills and trusts, normal estate planning. And then there's my department. Bridget Burns is the head of the Lawsuit Protection and Privacy Department, and I've got one partner, Elizabeth Tress.
Okay. Now, Kevin, you're the #1 leading expert attorney in trust law. What does that actually mean?
Well, I
know what it means for me.
Yes. My firm is probably in the 2 top in the country. And that assessment is really, I came in at the very highest level right after the Hague Convention was signed by the U.S., where U.S. citizens could establish trusts under other countries' law, and it would be the law of the land and recognized in the U.S. So essentially, we could do things with international trusts that would not have been otherwise legal under U.S. law. And treaties, conventions, presidential or decrees, they're higher than federal law. It's,
really?
Yeah, the only thing that's above that is the U.S. Constitution. Then we started having copycat trusts. I wrote a bunch of books in the early 90s right after the Hague Convention was signed, and I'd love to say I was particularly brilliant, but me and Arnold Goldstein had a book. There were a couple of other experts. They didn't get books out before the practice guides are now out there on it. But we became the speakers in the continuing ed arena all over the nation.
Kevin, let me ask this. A trust, you stated, was higher than almost everything except the Constitution.
Oh, the Hague Convention on Trust
okay.
that the U.S. government signed. So you've got municipal law superseded by state law that's superseded by federal law, and then there are these treaties and conventions above that, then the U.S. Constitution. So under a other than the Constitution, very high law.
Is that just irrevocable trust that we're talking about? Or?
Well, not just irrevocable, but if you're going to have a revocable trust, you don't get much privacy. You don't have privacy because you're named Kevin Day, trustee of the Day Family Trust. But with irrevocable trusts, you're essentially, under U.S. law, removing U.S. court jurisdiction.
Really?
So by us signing that, and all 50 states recognize it, the IRS, everybody recognizes it. So it's not just a black box, hey, trust me, I'm a lawyer. We'll get you
so
this.
let me see if I understand this and if I can somewhat regurgitate
Please.
what you said. Under trust law or under U.S. state and federal law, an irrevocable trust is removed from the courts?
If it's settled under another a different country's
I see.
law.
Okay.
And that was the first time. Until 1987, you could not, if you wanted to lawsuit proof something and you put it into the trust, you could not be the trustee or the beneficiary. So you had to give up all ownership and control. That's fine if you're a giant estate and you're giving it to your heirs and your charities, but if you're saying, I still might want to spend a bunch of millions on me, after I retire, I want to spend $1 million a year in Europe, and I don't want to give it all away. So it was not the law in the United States until the Hague Convention, and you could at that time only do it if you did an Isle of Man trust, a Bahamas trust, a Cook Island trust, where their country said you have a lawsuit-proof trust even though you name yourself as a beneficiary. So legally, you can say, I don't own all that stuff in the trust, and it's usually, but now, you get it all.
I have an irrevocable trust. I have one that's Georgia, and then I have one that you guys set up for us. Actually, we have a few of them and everything. So I don't own the trust.
I didn't say that. No attorney-client privilege was given by me.
Okay. Okay. So let's go. If someone had a trust that was irrevocable, that was set up, do they have any ownership of the trust?
They have beneficial ownership.
Okay.
And the trust is lawsuit proof because in the Isle of Man or in Cook Islands or in Montserrat, the irrevocability still allows you to, before in the US, you had to give up both types of ownership, the legal title ownership and the beneficial use of all the assets.
Right.
So these other countries have evolved. Business owners have a right to lawsuit protect their assets so they can still name themselves as a beneficiary and have all the use of it, but they need to put it into this trust. And so it is it's still your estate, it's still all yours to use, but if you get sued and somebody says, hey, you haven't written me a check yet, and they say, under penalty of perjury, you need to list everything that you own, you say, okay, this is what I own. Because the law says an irrevocable trust is an ultimate owner.
Okay.
And so just having a beneficial interest isn't enough ownership for you to say that you own this company and that bank account.
Ah, I see. So I would not have that ownership.
No.
Wow.
So you do have the ownership to go, let's say, to a bank for financing.
Kevin, I want to know a little bit about the minimizing the risk for companies and families. What is the true benefit, and how do you minimize that risk for companies and families?
Well, the whole process of lawsuit protection, minimizing, it's not necessarily, you think of minimizing risk as, do you have a good policy and procedure, you follow, that's all the normal stuff, but that can't control a lawsuit or the outcome if you do get a lawsuit.
Wow.
And that's the arena that we work in. And the basics that people have to understand about lawsuit protection, it boils down to, if you own it, it can be taken. Even if it's a deferred right. Somebody owes you some money, it doesn't start for 5 years, that judge is still going to go to that person. Instead of making it to Kevin Day, you make it to Mr. or Miss Plaintiff here.
Really?
They can do judicial foreclosures and all the rest of it. So a lot of business owners, and this is logical, it's good, they just didn't have all the good strategies and structures available to them. They go, wow, my wife and I, we own these different businesses, we own this real estate, and we're going to be the lightning rods, so let's put the cash and portfolio and something else that's high value in our children's name. And they have a lower lawsuit profile. But what happens if they get in the freak car accident or they get a divorce, and now what they considered part of the parents thought were part of their estate is now being taken? They did the best that they could do.
Okay.
Because you go into a lawyer, a corporate lawyer, real estate lawyer, or a trust lawyer, and you say, I want lawsuit protection. What do? You've heard it a million times. Oh, you have this many items? You need 8 LLCs. And that way, if this boiler blows up, they can't take your home or the other investments.
Yes.
But if you get sued personally, they're coming down and taking all of it. Even if the boiler blows up here and it doesn't get out of that box, you're still losing that apartment building or that rental. Our strategies of creating a separate legal owner, recognized as a third-party owner under the law trust, give back the control to the client with an underlying privacy company in Nevada or Wyoming, and then put senior liens on the equity. You can get a lawsuit because there's a horrible fire, and you will still have that home.
So when you say senior liens, Kevin, are you talking about UCC ones? What are we talking about?
Yes, there's 2 instruments to put senior liens on, and one is a mortgage or deed for real property, and UCC ones for everything else. So computers, freight trucks, warehouse stuff, cash. It was UCC ones. And our legal system, the first in time to the public record, not the contract. So if I'm carrying back a note from you, and then you get sued, or you go to the bank and get financing, and then I go, whoa, we signed a contract a year before, but I didn't tell the world that I had that right. So whoever puts the lien in the public record first will get every dime that have a secured interest. So this is just a friendly lien. You don't want to just throw a lien on, you can. It's a smoke screen, but we have to presume that the other side knows everything we know. I need to presume that I have to tell a judge everything I've done and it still work. So we create and work with the client to create the proper consideration, which is a legal term, to make sure that it is a proper deal, that this company, even though it's this company and this company, even though both are part of your estate, they have enough legal independence that they are entitled, and actually the law, the IRS code and the corporation code says they have to have as formal a relationship as me and Bank of America. And I'm not going to get any money from Bank of America unless they get a lien. So your little privacy piggy bank company or intellectual property company said, I'm not going to give you this contact list or whatever it is unless this is worth $3 million, and I'm not going to give it to you unless you give me $3 million of collateral.
Wow. Okay.
So you take something that you already have, you just put it in your left pocket, and the law requires you and gives you all these rights.
Well, now let me ask this, Kevin. Does the trustee have to disclose that I'm the beneficiary? Or
they could under extreme circumstances, but what we found in real life where our clients were under duress, that 80% of the time the other side doesn't even ask the right questions.
Okay.
They take it at face value that, you went to the bank, you went to this bank, you went to this maybe hard money lender or a private lender,
right.
And they don't even think to ask. They don't even bark up that tree.
Okay.
Some have barked up that tree because they go, they just have been in a few places. Well, of course, if you have good money and interest from a particular finance source, why aren't you going again, of course, to that same trough? And but so they might ask, well, do you own this company? You can say it's tactical. We should be able to say, hey, this is what we did. We did it 5 years ago. You can't touch it. But I've not met a litigator that says, oh, I've seen this 100 times, I can bust through this. I mean, you haven't seen this once, buddy or gal. They can't, but they spend, their client, spends $50,000 in trying to dig it out, and then you have to spend $50,000 explaining to the court and the other lawyer what the law is on these trusts. And these guys were never trust lawyers, litigators, they didn't come from this field, they don't know it. But because it's a separate legal owner under the law, nobody owns a trust, just like nobody owns a human, nobody owns you or me. So this trust is standalone.
So what you're saying, Kevin, and if I'm the beneficiary, I don't own the assets in the trust. Do I control them?
You can't control it at the trust level because then you became a trustee and you also have beneficial ownership, so you've merged the two that make it lawsuit proof.
Okay.
So, but you can manage the underlying company. So 99% of the time, we're creating irrevocable trusts that are dormant trusts. An active trust is like a Carnation grandchild or a Kennedy grandchild, has to go to the trustee, New York, Bank of New York Trust Department and say, I need, a business ticket for me and two of my close friends, please pay for it. I want a new house in, Portland or whatever it is.
Well, I got to ask this
That's
question.
an active trust.
Our President Trump, had a trust, several different types of trusts, and the state of New York kind of broke or pierced their veil. What happened there? Why wasn't he protected?
That was already out in the public world. He kind of flouted it, or let it be known so people knew about it. Some very high-profile things that were related to him also had the trust on it, so they presumed they were related. So we're not going to name it, the Kevin Day Trust. It's going to be the Pine Tree Trust or the Golden Mountain Trust.
Okay.
And going back to that question of control, every entrepreneur, no matter how much stuff they do, how much management that they may release to competent employees, they should never let the checkbook go, in my opinion. I've never seen an entrepreneur, well, that's why 99% are these dormant trusts where the piece of paper of ownership is into the trust, but no bank accounts, nothing's up there.
Okay.
It's down in underlying privacy company like Delaware, Nevada, Wyoming. Nevada is the best. They adopted Delaware law, but Delaware is so focused on the public company, and public companies have their uses, but for a personal piggy bank, you want it in Nevada, in my opinion. Okay. And you have privacy, so your name isn't in the public record. You are the manager. You can buy and sell just like you normally would, but it's going to be in Northridge Enterprises or Golden Mountain Financial. And the law is very clear. I've had attorneys that were not partners, they had no ownership, that were signatories on my bank account. They had no ownership, even though they had access.
Right.
So being a manager, having the checkbook imputes no ownership. So it does not make you a trustee. So here you can control it. The trustees have a piece of paper, so if you get sued, you have a perfect position that it's going to be lawsuit protected, but you still can buy and sell just
now,
like
Kevin, you've been in business as long as you have been practicing law. I know you have many horror stories. Can you just share one or two with us?
Yeah. Recently, and not naming names, but it was recently, a real estate owner bought an existing apartment complex. I think it was like 18 doors, and he came on the scenes, and the tenant said, "Hey, we want some lights in the back because our kids can't play because of the change, and it's dark when they get home at night." So he granted them that, but he went beyond that and had the office manager make a little, basketball court. Not a whole court, just a half court, a hoop, and some cement. And he was great. He was a good guy. Nice gal doesn't mean anything in a lawsuit. Unfortunately, the manager hired unlicensed normal handyman around the place, and a 12-year-old kid grabbed hold of the chain link fence and got electrocuted to death.
Wow.
So here was a good guy being a good landlord, going out of his way to be better for his tenants, and big lawsuit and a lot of equity loss. Didn't have to happen. And a lot of us, we all drive.
He didn't have the irrevocable.
No,
truck.
he had been talking to us about it, and he never got off the dime. Or like some people, they got some of the structure, but they didn't connect all the dots.
That
and
reminds
that
me
hurts.
of years ago when I lost my nursing home businesses and everything, and it was like I kept saying it, and over I said, okay, I got to finish this. I got to tie it and transfer the ownership. And I kept procrastinating, and I never did it.
I found a new building. I need to pay attention to that. Buy another one.
It was like, and when all of a sudden I had regulatory problems and everything, and I said, oh my God.
Yeah.
Oh my God. And what I remember being told that if I had done everything I was supposed to do and finished that process, because I owned the buildings, no, I'm sorry, I didn't own the buildings. Because the buildings would have been transferred over to the trust could have continued to collect rents on the buildings and things of that nature.
From whoever might have owned it or operated it.
And so it was tragic, because I was like at a point in my life, because I lost 118 million.
Yeah.
We had over 500 employees and everything. We had 13 nursing homes, 8 assisted living facilities, and it was crazy. And so I was like, okay, and I was going to kill myself, do all kinds of things. I was like,
180 million is pretty tough to swallow.
It's a lot. And I didn't think a guy like me, coming from where I came from, that I would ever make that kind of money back.
Yeah.
And I knew it was my fault. I couldn't blame anyone else because I knew that I should have finished it and not procrastinate and placed everything in that trust. And if I would have done that, I would have still had income and everything of that nature. I could have won
It wouldn't have had to start all over
exactly.
and brought yourself back up to
And
where you are
so, how many people do that what I did out of either procrastination or just ignorance?
Let's say let's say out of 100 people, there's probably, I hate to say it, there's probably about 20 of them out of 100. That's a lot, I think. When they've spent good money, they've done little parts, but didn't get one last piece that we needed back to do a document. And we hound, we really pester entrepreneurs. They're entrepreneurs because they like the next thing, and they're balancing. Hey, I can balance 10 balls.
I was so focused on these millions of dollars coming in, and it was like, I'll get to that. I'll get to that. And even in MBA, I've got an MBA. They never teach you about structuring. They presume you're going to have one company and it's going to do everything, and you're going to have employees and it's going to own a building. They don't even talk about you have to learn hard knocks, other mentors. Oh no, you have the building over here and you lease it to where the employees and the end users and the consumer or the product user is. You never put that building in there. This can blow up too easily. And you're your own tenant, so you're not going to sue yourself. But when you have apartments or you have rentals, you never, the tenants never know what you went through and what you sacrificed to build that. When I started my firm, I literally started with $500 in my bank account and a Fugent suite, office, and within a year I was still eating, law school student, steamed rice, collect a couple dollars so I could eat at McDonald's. But within 6 months, I had 4 attorneys coming that had offices and employees coming to me to pick up work. Wow. They started working for me. And I had a vision and it worked out. So, but going back, nobody teaches, it's all about how to make money and reach more people and make a better widget and come up with a formula that's gonna make you and other people satisfied. Nobody talks about,
hey, let's pay attention to keeping what you worked how many years to build?
Yes.
You know? And what I've found with everybody, if you get up to about $3.5 million, most of your creature comforts are taken care of. Now you have disposable income. Then so many people have come to me and said, wow, and I've benched that out where people have come to me below that or during that or after that, and there's enough money that starts making the money. They're not pushing the ball so hard for every single dollar.
Right.
They've made just enough. So once they feel that money can make money for them instead of them pushing the ball, they go, I never want to start over again.
Well, Kevin, when is the best time for an entrepreneur to start this? Is it after the business is going, before? When is the actual best time?
The best time to do it before you get sued.
Okay.
But we don't have a mystic crystal ball that we can figure that stuff out. So the academic answer is you do it kind of simultaneously as when you start your business.
Okay.
So
that early?
The only way to attack an irrevocable structure is to allege and prove fraudulent conveyance, that you had known existing creditors already and you were setting this up to not have to pay them or whatever. But if you enter into a contract with somebody, 3 months later, that's impossible to be fraudulent conveyance.
Really?
If you meet somebody in the crosswalk, a week later and they're paraplegic and they got a $3 million. There was a single.
Well, let me cut you off for just a sec, because
Yeah.
for my audience,
You know what they're interested
I want
in.
to go back and just recap that. So the best time to establish the trust and to protect their assets is at the time that they start their business.
Yes.
Wow. So that's when they need to call you.
Really, and it's hard, and we understand that because entrepreneurs usually scrape all this money together for this new project, and they need that money. They need to buy new business cards. They have to buy a new logo, website, and all that stuff. So what's lawsuit protection? I can't afford it. So we can do, we call it road mapping, is to try to see what is the perfect structure, that if money was no object, what would we put in place?
Okay.
And now let's get economically real. What should we start to do first? Instead of being just an entrepreneur and say, oh, I need a new company here, there, and there, and you formed 4 more companies than you needed. You should have created this one first. And so, like all of our friends and you have said, know where you're going, you'll get there straighter and easier and faster, right?
Yes.
So you want to know where you're going, and then you can start budgeting for it. And unfortunately, the trust, which is the most solid lawsuit protection aspect that you can have in this country or in Europe, is not entrepreneurial friendly. You have to have an underlying company.
Okay.
So if somebody is road mapping, nobody wants to go ask a trustee for stuff. Nobody's going to put the checkbook in their name. So we start with the privacy company.
Okay.
And then when we can budget for it, we want to make sure a company that doesn't have the people's name on it, it can start licensing intellectual property or loaning back. It's just money from your right pocket and left pocket, but if you're using legal constructs, that's what you need to do. They're separate legal people. The defect in that, which is just tactical, is if somebody barks up that tree, you're in that 20%, and they say, do you own Golden Mountain Funding that has liens against all this and has a prior right on income on this sales contract? Do you own it? And you're able to say no, because
so
it's
you're
in the
able to
trust.
legally say no because it's an irrevocable trust.
You put it in the trust. But if we did the stepping stone fashion, They ask the right question for the wrong reason. They don't know about this stuff. They think that you sold it to your sister for $10 last night before the deposition, and you're going to buy it back for $10 after the deposition. So they ask you, do you own it? And you say no. And have you ever owned it? You can't perjure yourself. That's a felony. It's against the court, not your adversary. And so if you're able to financially do both at the same time, when they say, do you own it? Nope. Have you ever owned it? No. Well, can you prove that? Well, go talk to that company. And then we'll have lawyers representing that company and CPAs that come forward and say, we're the CPA for this company and we're the lawyer for that company and we know who the owner is, attorney-client privilege. We can't tell you who it is, but we can tell you that it is not, Sally Jones or
Now,
Billy.
I know the answer to this, but I'm going to ask this question.
You know a lot.
So if I'm the settler
Yep.
of the trust, is that ownership?
No, a settlor means you settled it, you pushed it all into motion. And you might be creating an irrevocable trust for your children and grandchildren, a dynasty trust that'll go on for generations where you're not the trustee or the beneficiary, you're a settlor. Or you can set up a trust where you're naming yourself as a beneficiary and you're still the settlor. So being a settlor is actually the giving away process and the formation process. No ownership.
Now, Kevin,
Settlor is not
trust
owner.
law is so specialized, and you're at the top of the field. You're the man to go see in the United States about trust law, okay?
Thank you.
Why no attorneys know or understand irrevocable trust, or if you just go to an attorney? And what I'm trying to get at, Kevin, is they can't just go to an attorney or someone that does wills, or they say they do a living trust and get a trust. They really need to come to a specialist like yourself.
For this purpose, absolutely. And I don't mean it in a derogatory way. There are a lot of estate planners, all they do is wills and trusts. And it's important because they do a lot, and they drive down the costs, and you can avoid probate, which just saved your family $50,000 that was going to go to some lawyer, when instead you could have spent $2,000, $2,500 to have a trust that doesn't need a lawyer to go run the probate. It's a no-brainer. And we're talking losing 6%, 4 to 6% of your estate by going through probate. That's
How much?
4 to 6%.
Wow. That's a lot. That's huge.
So that's why a lot of lawyers, it's kind of a lost leader. Oh, we'll do your will for $900. It takes more hours than that to interview and do the drafting and do all the notarization and everything. They put their name all over it, so when you die, your heirs go to you and, oh, yeah, he has a will. We're going to do a probate now.
Okay.
And then they get bank.
Kevin, I had a friend, she was telling me about a trust that she had, but it wasn't a irrevocable trust, I think, out of Charlotte. And I said, well, that doesn't sound quite right. That doesn't sound like what I have. And she was like, well, it's a trust, so I have my house in there and things like that. But the attorney told her, well, in North Carolina, you don't have to worry about anyone ever taking your home because they can't. And I said, that really doesn't sound like that's right.
Everybody has heard of this thing called Homestead. If my house is homesteaded, I get to keep it. And in the old days, that's what a homestead was. You wouldn't lose your property. Every state has eroded that.
Really?
Except for Texas and Florida. O.J. Simpson sold, he had a trust in the Isle of Man. That wasn't even touched. He had his pensions that were ERISA protected, and he tried to sell as much as possible, and he bought the biggest value that was in the confined space that was fully homesteaded in Florida. Texas had such a big ranches there, right? And home of homestead, right? You think of the ranches, that's a homestead. You don't really use it back in Balmer or South Carolina. So it was so strong, you had 100% homestead, and a guy that had a skyscraper, and 16 stories, and he owned the penthouse and everything else was rentals. The homestead covered that because his home was on that property.
Wow.
They changed statutorily. They said this is just not what the law was intended. But in California, what they do is they still judicially foreclose on your home, and the homestead, if you have filed it with the court, you get $67,000 or $100,000 just so you're not a ward of the state and you can go pay rent at an apartment. They're still
Really?
taking your home. And that's what
But
all the
they're
other states,
compensating you
except
for taking
Texas and Florida, you just get a chunk of money so you don't have to be a ward of the state and you have some rental money. You're losing the house.
This attorney, and I don't want to bash anyone here, said that she didn't need the trust because the state, if somebody slipped and fell on her property, they couldn't sue and take her property. So that's just incorrect. Because that's what I told her. I was like,
Yeah.
I never heard that. That's crazy.
Yeah, I mean, everybody heard, even if they've never seen a movie with it, everybody knows the term slip and fall.
Yes.
And if it's on your property damaged them. If you have a trench for some up on your property and you have no soliciting, no trespassing, if somebody comes in, doesn't see the trench, they're dark, they put it in, break, and get some weird kind of infection that goes into their marrow, you are losing that house if you haven't done other lawsuit protection. Here's another frequent, I've got so many horror stories.
Please.
A burglar admitted that they were there to burglarize this home, fell in through the skylight that he had undone and was coming down to. He slipped and fell on a glass coffee table.
Don't tell me he sued.
He sued and won.
Really?
A couple $1 million, like he had, the law said that they had a legal obligation to somebody slipping there. Now, if they had somebody doing
So the law
re-roofing or somebody,
protected the burglar.
the criminal,
Wow. Wow.
because he got all lacerated up and all that. Another one was where this guy had, it was Friday, he's coming home from work and he's realizing the brakes aren't working. He immediately, he goes up and parks it in his driveway. He calls his mechanic and he said, we're kind of closing up right now and we're not open on the weekend, bring it in on Monday, or we'll come and pick it up on Monday. And somebody stole it on Saturday night. He wasn't on the public street, it was up in his driveway. They get to a light, they put on the brakes, boom. Who do you get to sue? The driver and the owner.
Wow.
And the
They
narrative,
stole the car,
didn't have any money to
got
pay.
in an accident, so they went after the deepest pockets.
Yeah.
The owner of the car.
Yeah.
Wow.
And won.
Wow. That is amazing. All right, I'm going to read another question. What can people do at a bare minimum to protect themselves?
Well, certainly the regular strategy, separating different assets in different companies, but you're still going to lose that apartment building if it catches on fire, because that's the thing that harmed them. And also, if you don't have to hit a school bus full of children to get into multi-million dollars. You can hit a family of 4 and get way outside of insurance limits. There was just a case that my partner found up in Orange County or Los Angeles that one single motorcycle rider got $27 million for his damages. That's just one person. And so the strong is not necessarily the simplest, but getting a privacy, Nevada or Wyoming company where your name isn't on it, even if you don't have a trust, to put liens on. See, that's what's so great about these privacy companies, that either have IP or other things for proper consideration, it's the only instrument that can lawsuit-proof your business assets, accounts receivable, and your home assets. Most of the other things are either protecting your home or protecting your business, or shielding parts of business from other parts. This third-party outside interaction, an asset is an asset if there isn't any equity in it. If I get a judgment against you and I see Bank of America has 50%, 80%, and I go, hey, take your lien off, I have a judgment. And they say, that's why I'm there. I get every cent, And so if there's no equity there, there's nothing to take.
So Kevin, I have a lot of clients that I consult now with that I get to buy stocks into the various companies that I invest in and take public. And I always tell them, look, you need to go see Kevin, his law firm.
I've always appreciated that. Thank you,
he's
Mr.
the
Ali.
best at what he does. There's no expert that's an attorney that can compete with you in the structures and the things that you have shared with me. And some people say, well, it's too expensive. And I said, well, I know. But try losing everything you have, and then you'll find out how inexpensive it truly is. And so they do stocks and bonds and promissory notes and things like that. And they say, well, does that work? I thought trust was only for real estate. And I said, well, no, it's working for me. So can you speak to that, the stocks and the bonds, convertible notes that people owe?
Yeah, we have. So as a lawsuit protection attorney, our main thing when we start working with a client, this is an oversimplification, but we say, is this high liability but not very valuable? Is this zero or near zero liability, like cash and portfolio and notes? There's not much liability there. Or is this really high value and high risk? It makes maybe the main cash flow into the family, but it's higher risk. So what do we put in the lawsuit protection side? What do we put on the standard, normal living trust side? And if a client's going to get sued anyway, they're the lightning rod. We're not going to put something high liability with the cash and portfolio or notes, anything like that. We have people that have gold and silver. We have somebody here that has an incredible real art collection, like in a museum. So we make sure, and we do all the documentation so we can show that it's owned by this legally third-party part of their estate plan, but there's a contract back that they are the one to be the custodians of it, not put it in a closet and get black mold on it and stuff. Okay. So it's on their walls, but they're getting paid to kind of take care of them. Okay. But if a creditor comes in, they don't, they can take furniture and everything else out, not just foreclose on the home. Okay. So.
Well, I see everyone at Magnify Your Wealth is starting to come out, and I want to thank you for coming in and sitting and sharing your knowledge and your expertise at Minority Business Access. So how do everyone reach you?
My phone number is 858-755-6672. That's 858-755-6672, or Kevin, Kevin, at trespday.com. That's TRESPDAY.com, and either one will reach me.
Well, Kevin, thank you so much. Appreciate it, and thank you for all that you have done for me.
Thank you, buddy. It's always been good with you. Thank you.
You've reached the end of another episode of the Minority Business Access Podcast. Connect with us at solomonrcali.info to leave a review and access more resources. We hope you enjoyed this show and found great value. See you at the next episode.